Hi, I'm Schaefer Aude. I'm going to be going over section 4.1 from A Gift of Fire, which talks about intellectual property and focuses on the concept of copyright. So what is copyright? Basically, it's the idea that intellectual property should have certain protections. It's the idea that the owner of a creative work has certain rights, certain uses of that work that other people aren't allowed to use. So it's literally the right to copy, but it includes other rights as well. And it applies to creative works. So that means things like books, movies, art, but also importantly, some software. In the United States, copyright law gives the owner of the creative work the following rights. That means anyone else is prohibited from these uses. So they're the only one who should be allowed to make copies, distribute copies, produce derivative works like a movie adaptation or something based on the original work. The copyright holder is the only one who can display or perform the original work in public. And we want to distinguish copyright from other forms of legal protection for ideas. Like copyright is specifically for intellectual property and creative works, as opposed to things like business processes, methods of operation, factual ideas. Those things can be protected by other things like patents or trademarks. It's also important to note that when you purchase a copy of a work under copyright, that grants you the rights for your own personal use. But that's different from purchasing the rights to the intellectual property itself. And purchasing a copy of a work doesn't afford you the privileges that the copyright holder has. Here's a quote from A Gift of Fire that I thought was useful to illustrate the concept of intellectual property, and that the thing that they're trying to protect is the intangible creative work, not any particular form or distribution of it. Why do this? Why does copyright exist? Well, from the perspective of those who are the creators of intellectual property, there would be little incentive to put their effort into their work if it was really easy for anyone else to reap the full benefits of their work by copying or distributing it. In general, the more a creative work is copied, the easier it is to be distributed, the less valuable it becomes as an asset to its original owner. And besides the actual creators themselves, there's a lot of industry. There's a lot of people who have their livelihood vested in creating and distributing these products. Like the publishers and companies, they're heavily invested in being able to control the distribution of intellectual property. But there are a lot of times it seems like copyright is unnecessarily restrictive, or there are times it seems like making copies should be ethically allowed. Especially in today with digital media, oftentimes creating copies of digital media doesn't seem to have a tangible negative effect on the other copies. It doesn't decrease their use or enjoyment. It's often cheap or easy to make the copies. And there are other reasons as well that copyright can be potentially a hindrance. For instance, the idea of parody or satire can be a valuable thing to have. You would like to be able to critique works, or if you feel the opposite way and you want to build on an existing work, especially for like an amateur level creator, copyright can make it really difficult to do these things, to get the necessary permissions to make works based on other works. There's also an argument that allowing people to sample a work can help them decide whether they want to actually make a purchase, and then can actually improve sales. We should talk a little bit about copyright and its history in the United States, in particular how copyright law has struggled to keep up with the rapid advance of technology. Here's a very brief history of copyright in the United States. So the idea of copyright was first put into law way back in 1790, and it only protected books, maps, and charts, and it only lasted for 14 years. It wasn't until 1976 that software was first explicitly included in copyright law. And the idea was that if the software exhibited creativity or original authorship, it would be considered intellectual property and covered by copyright. So then, in 1982, it became a felony to make any kind of high-volume copying of like music records or movies. In 1992, even a small number of copies of copyrighted work, if made illicitly and for the purpose of commercial gain, even a small number of copies became a felony. And then in 1997, it became criminalized to willfully infringe copyright even without any intention of commercial gain. So you can see the trend over time is that the laws have become more restrictive and the penalties have become more severe. This is because of a combination of factors. Technology has advanced rapidly, especially the advent of the ubiquity of the internet has made it much easier for many individuals to not only create their own intellectual property, but also easily and at a low cost copy, distribute, and share. And especially in complex or technological arenas, Congress often delegates the drafting of those complex laws to industry experts. So the result is, for most of the 20th century, intellectual property laws have increasingly represented the perspective of like publishing industries, so they've become more restrictive and punishing. So to help evaluate what uses of a work should be prohibited or allowed by copyright, there's a concept of fair use. The fair use doctrine was created. Based on previous judicial decisions, it became officially part of law in 1976, and it attempts to give some criteria that help us evaluate whether the use of a creative work is fair. But note that in 1976, this was before the rise of widespread internet, so it doesn't really specifically address internet-related situations at all, which are really relevant now. But that said, these are the 4 specific criteria that help us evaluate whether copyright should be enforced. So they are, first, the nature of the use, whether it's for commercial purposes is going to be a lot less likely to be allowed than something that is for nonprofit purposes, and also the nature of the work. Something like a fiction or something created for entertainment is going to be a lot more likely to have its copyright restricted than something that is educational or nonfiction. Also, the amount of the copyrighted work used or the significance of the part used is also evaluated to play a role. But in the end, the most important factor of all is how they evaluate the effect on the original copyright holder, how much this use of the work affects the original owner's value or marketability of the work. So, since fair use doctrine was adopted into law, there have been some significant legal cases that set precedents about copyright and fair use. In 1984, Sony was sued because they were selling a video cassette recording machine that could record from the television. They were sued by movie studios whose movies were shown on TV, and the court ruled that as long as it was for personal use, copying an entire movie with the cassette recording machine was considered a fair use, because they ruled that just because Sony's device could be used in this way, Sony shouldn't be penalized because people choose to use it this way. Then later, in 2001, with the advent of Napster, Napster provided like a central service that allowed their users to copy and distribute songs over the internet, and it also showed catalogs of what songs were available. And the court ruled that Napster was liable for damages to record companies for distributing these songs because they were encouraging copyright infringing activities and had a financial interest in those activities. And they had the ability to supervise their system, and the way that they did so encouraged copyright infringement. Then in 2005, there were many file sharing services rose up using peer-to-peer sharing. So they didn't have any central service and they didn't list what was being shared. They simply provided the means for users to share files. And one of these was Grokster, and they were sued by the record industry again. And so even though it seemed like the file sharing technology had a lot of potential for productive legal uses as well, in this case, the Supreme Court ruled that the intellectual property owners were in the right, and that even simply facilitating this file sharing was counted as encouraging copyright infringement. This is just another instance of how the laws over time have become reinterpreted in more restrictive ways. So, to wrap up, copyright as a whole is often complicated and nebulous, and although we have the fair use doctrine to help us, the rapid advancement of technology means that intellectual property law is constantly adapting, and there will always be some contention surrounding what copying is ethical or legal. That concludes this presentation. Thank you.